Hello, everybody. We're really happy to be in the beautiful city of Buenos Aires for our Avalanche Summit, LATAM. And this panel is going to be a special sampler of several legal issues that you should care about. But before I get started, I would like our panelists to introduce themselves very briefly because each of them represents a special area among the legal world. So, Sean, would you like to get started?
Sure. So great to see all of you. My name is Sean McElroy. I am an attorney at Fenwick, based out of Seattle, Washington, and I work on basically all things related to tax and blockchain. So I've worked with pretty much every kind of, from individuals to companies to big and small, all types of projects within the space, and kind of cover the whole range of it and worked on it pretty much my entire career.
I'm Justin Gunnell. I'm a partner at Sher Tremonte. I'm a generalist litigator, so handle cases concerning business torts, IP issues, and everything in between.
My name is Olta Andoni. I'm general counsel of Enclave Markets, which is a subsidiary of Avalanche, and I handle everything legal, regulatory, compliance related for a crypto exchange.
Not working, but I'll just speak loud. Hi everyone, I'm David Forst. I'm a partner at Fenwick. I split my time between Chicago and Wyoming. I, for the last 7 to 10 years, have focused more and more on crypto, cover the waterfront with it. Particularly relevant today, I do a lot of fund work with respect to crypto.
Thank you, everybody. And just a quick intro for those that may not know me. My name is Sylvia Sanchez, and I manage this amazing initiative called OWL Explains, which is a channel through which we communicate both with policymakers and regulators about what blockchain technology is. We give them solid explainers about what's happening in Web3. And it all began with this amazing idea that Lee had of creating this channel to explain these topics in a more digestible, accessible way through our podcast, our comment letters, and also these types of panels. So before we actually get into the questions, I think that I would like to start with a little structure, like this little illustration of how we have organized this panel. So as you can tell, each one of them has different backgrounds. We have our litigation expert, our tax expert, AML, investment management, and this is not really going to be just litigation or just investment management. Think about it as tapas. You know, when you're going out and you have a tapas dinner, you have little plates, you have the olives over here, the cheese. You're not going to eat the whole plate of olives all at once. It's not going to be just one and one. No, we're going to sprinkle in some different topics among each other, and even though they are different, they're all intertwined. There's a lot happening in the industry. So we're going to get started with litigation. So Justin, you are our litigation expert, and it's definitely an interesting topic to get started. And there have been some unique litigation tactics that are emerging in the niche legal disputes, particularly involving digital assets and intellectual property. So can you share some of these tactics and how they're shaping the legal landscape?
Sure. When I think of tactics, specifically in this space, I think of two things in particular. One is it's oftentimes hard to figure out who to sue in certain situations. There may be situations where somebody was defrauded and all you have is a wallet address, or maybe you know of a DAO or something of that nature, but you don't have an individual to actually proceed against. So courts have been grappling with this over, very recently and within the last few years, what tactics and techniques can be used to find the proper party. We saw that with the Uki DAO case out in California. In that case, the judge actually allowed the plaintiff to go, it was the CFTC, to go after a DAO, a decentralized autonomous organization, which are often part of their organizational structure is to keep things anonymous, but they also have as part of their structure usually a governance component where holders of tokens take part in that governance. So in some ways it is like a traditional entity, but it's not organized as such. And the court in California, applying Federal Rule 17, said it has the capacity to be sued, and it was sued as an unincorporated association. So the court in that instance was willing to be flexible and allow the plaintiff to go after the party that, and in that case, was the perceived wrongdoer. There was another case out in California, the Sarconi case, and they allowed a DAO to be sued. In that case, under a slightly different theory, everyone who held a token was considered to be a general partner in the DAO, and thus every single token holder was jointly and severally liable, and the plaintiff could go after any token holder. That's great, from a plaintiff side litigation perspective, that's great. From somebody organizing a DAO and holding tokens, that is, an obvious risk. So you may want to, in that situation, be mindful and sort of wrap the DAO organization in a more traditional structure, like an LLC, where you can enjoy some limited liability. But it is interesting from my perspective to see the courts being flexible and allowing parties to go after sort of unconventional organizations. Similarly, there's always been Jane and John Doe lawsuits, but that's more common now when you're going after a wallet and just a wallet. There was a recent case in the District of New Jersey where the court allowed 4 subpoenas and discovery on Coinbase before the Rule 26 conference even started to help get identifying information for the proper parties. So I think that's certainly one of the tactics that I'm seeing. And then the second one is service of process. Normally, that has to be done through personal service for obvious reasons. You want to make sure the party that's supposed to get notice of a lawsuit gets that notice. You've been served. But what we're seeing now, and in my home jurisdiction, I practice in New York, and one of my primary courts that I practice in is the Supreme Court of New York, and the commercial division there, just 2 years ago, Justice Maisley issued an opinion. It was the first in the country, and she allowed service of process through minting a service token and then airdropping the service token into the offending wallet. First case of its kind. Since then, other district courts throughout the country have used Federal Rule 4 and sort of under similar reasoning allowed that to happen in other situations. The obvious concern is due process. Is the person actually getting notice if you conduct a service in that manner? But what the court said, at least in that particular case, was the wallet still had plenty of money in it, over $1 million. They could see that the wallet was being actively used, so they knew it was being monitored. And it was the wallet that was tied into the alleged fraud. So for all those reasons, the court felt comfortable that due process was met and allowed, sort of this NFT-based service, which is, first of its kind, right? Back in the 90s, email or 80s, emails was the first of its kind to allow sort of alternative service through email. Now, like airdropping and NFTs, it's pretty, it's the next logical step in that. So that those are two things that I thought were pretty interesting. And in terms of the minting of the token, the token itself linked to a hyperlink to a website that had all of the court documents, so it was still providing all the information just in this very new and innovative way, which was designed to get at that particular fraudster. And same thing in the UkiDAO case, they actually allowed service through a message board that set up the topics, for the DAO to vote on. So courts are, just the overarching point I think in all this is courts are being flexible in both who to sue and how to get notice to those people that you're suing. And those are some of the prime trends I'm seeing in litigation over the last several months.
Awesome. Thanks, Justin. That was a great overview. So let's shift gears a little bit to the tax implication of crypto. And here we have Sean. So a big section that is worth mentioning on this part is the OECD's tax framework. So what can you tell us about the OECD's tax framework, particularly CARF? We have a diverse audience, so I think we can give a bit of a background on that. And first of all, what it is, what it's not. Take it away.
Absolutely. So I'll start really broadly with what the OECD is, because it's an entity you might hear about, but it really has an important role in global tax policy. So the OECD is a group of, I kind of think of roughly the G20 nations that come together to write laws and write sample laws that various countries will implement in order to carry out global tax policy. It's very important in Europe, South America, all over the world. In the US is kind of a love-hate relationship with the OECD. It can really depend on who's in power, what's going on. It's not really along even political lines. Different administrations have tracked closely to the OECD. Others have kind of strayed away from it. But the OECD is its big area into blockchain has been to create something, the crypto asset reporting framework. So what CARF is essentially a reporting tool for governments to each report to each other what activity is occurring and who is covering that activity to make sure that what they deem to be all crypto transactions and crypto activities are ultimately being picked up by governments. So it really is this very complex system that they've built out, but it really is the first international reporting regime for crypto. And I think pretty much any exchanges or any types of, I use the term broker, but folks brokering assets are going to have to think about how they fit into CARF. The other factor is that it looks like the U.S. is at least saying very publicly, it will participate in and adopt CARF. So how that will happen, whether that requires Congress's act, whether that can be done through regulation, a bit of an open question, but how this kind of information sharing occurs between governments is going to be a major issue going forward.
Great, thanks for that context, Sean. And just following that thought, my next question is for David, now that we're on this line of taxation. How does this framework interact with existing US reporting requirements? What should businesses be aware of?
Yeah, Sylvia, that's a very, very hot topic right now in the United States, because in 2021, the US Congress added one sentence to the Internal Revenue Code, which is tens of thousands of sentences, and basically it said that tax reporting for crypto has to more or less mirror tax reporting for conventional securities. Now, that's fine as far as it goes, and I don't think that was terribly controversial, but what we have seen is the IRS has written hundreds of pages of implementing regulations that are partially finalized right now and partially still proposed, that will take that reporting mandate from Congress and expand it well beyond the reporting requirements for traditional finance. And that's a major issue in the United States right now, because with highly expanded reporting comes a potential chilling of the industry and potential burdens placed on the industry that are not placed on traditional finance. And that's what we and many others are working through right now.
And if I could add just one quick bit on that, two quick things on that. One is that regulations on this and additional regulations are coming soon. It's an interesting political year in the United States, as many of you might be aware, but this administration does want to put things out quickly and have publicly said that they want to put things out by the end of the year that will do this. The second is that this is not, the IRS takes a very broad perspective on its own jurisdiction as to reporting. The regulations say it has broad jurisdiction. I think many individuals within the blockchain space, many companies within the blockchain space that aren't US-based companies but might have US users, might have potential US users, might have US operations, all of this could be brought within that framework, and the IRS could take a very aggressive position on that. We don't know because we haven't seen the final regulations on this, but it's very possible that it's not just a US issue because of how aggressive this IRS is in the space.
Thanks for that. And now let's talk DeFi. Let's go over to Olta. So I'd like for you to talk about the CFTC DeFi enforcement actions, the DeFi sweep, and the overlay of CFTC regulation in DeFi.
Absolutely. At least you're not asking me about tax-related questions. Sylvia, yeah, we're seeing a lot of more action from CFTC. Previously, we saw some low-profile enforcement actions against the exchanges, but I think, unfortunately, right now the attention of CFTC is toward DeFi protocols, which also goes, I would say, truly goes against the ethos of DeFi, which the purpose of DeFi, as we all know, is disintermediation. And it seems like with these actions, recent enforcement actions, especially against the three DeFi protocols, definitely CFTC, the compliance structure that they're asking for DeFi protocols is of course, to put DeFi under regulation. The DeFi sweep actions are quite important, I think, for the DeFi space. So we saw CFTC enforcing 3 actions toward Deridex, Open, and 0x as well. And I think for Deridex and Open, they accuse them for offering unregistered swaps, and I think also for failing to identify their customers under the Bank Secrecy Act. To be honest, I think that the more I read this complaint, I think that Deridex, in my opinion, was truly a theater, because I think that the control, decentralization theater, to emphasize that, because I think the control was way beyond the mere kill switch. And I think, they were able to do every controlling, despite pretending that they were fully decentralized. I think for the 0x, if I'm not mistaken, I think the CFTC accused them for trading third-party tokens via their front-end application, match application that CFTC alleged that should be offered only on centralized and regulated exchanges. So definitely, these are actions to pay attention to, because, and then we saw the Uniswap action where CFTC accused Uniswap for trading of exchange leveraged crypto commodities. I think that Commissioner Mersinger has done a tremendous role, and I think she's a big advocate for our industry, because with both dissents, she has some strong dissents both for the actions against the 3 DeFi protocols and against Uniswap. First of all, she emphasizes how in the previous 3 actions, there are no allegations of fraud on those actions. So even for these DeFi protocols to comply, we still do not know the regulations that they fall under. Especially also we see, I want to jump a little bit for MiCA, because it seems that also DeFi protocols are going to have their obligations to comply with MiCA, and supposedly MiCA was supposed to deliver, I think, a DeFi, DeFi regulatory explanation, but I don't think we're going to have that regulatory explanation or how MiCA is going to be applicable to DeFi protocols until probably by next year, even though it was supposed to be December, I think. Thanks. So a lot to digest here. I wish I could talk more, because, as I said, there is a lot of more action, unfortunately, from CFTC against DeFi, decentralized finance.
Indeed, thank you, Olta. So that's on the CFTC, and now let's go to the other big player, which is the SEC, the Securities and Exchange Commission. So, Justin, the SEC has recently been quite active in cybersecurity enforcement, particularly with cases like SolarWinds. So, can you discuss what these actions mean for businesses? What have you seen with that recently?
Yeah, SolarWinds was a case first of its kind. It was the SEC going after a company for its representations surrounding its security systems. That's something we hadn't seen from the SEC before. It was the first time they put together an action like this. They were somewhat aggressive in the claims that they brought. Not only did they bring material misrepresentation claims, but they also brought a claim under the Exchange Act Section 13 for not maintaining proper accounting controls and for inaccuracies in the Form 8K. Just this summer, Judge Engelmeyer in the SDNY, where the case was filed, dismissed most of those claims. I guess for obvious reasons, the accounting claim was held that cybersecurity issues were not accounting controls, which seems obvious, but I guess not to the SEC, and also dismissed the Form 8K claims as finding that the company actually did properly disclose the cybersecurity risks that were involved in the hack at issue in their Form 8K. However, I think what's still important is the entire case wasn't dismissed. So what's interesting is there was a security statement that SolarWinds put out on its website, and it wasn't even investor-focused, it was consumer-focused, but it made claims like, our password protection is really strong, we have really secure networks, we take your data very seriously, and things of that nature. And behind the scenes, the SEC was investigating, and the Chief Information Security Officer of the company, the CISO, was actually giving presentations to staff at the company saying, we have a lot of vulnerabilities with our security, I'm worried about this, our engineers can't keep up with the problems that are happening. So there was this disconnect between the public-facing statements and what the company was experiencing internally, and the judge found that that was enough to meet the Sienta requirement, both in terms of the company and the Chief Information Security Officer, so there was even individual claims that moved forward. And what was interesting here is this was sort of a security breach, very, very long in time, that created a backdoor to this IT software that was being used. So it affected, 18,000 to 30,000 customers, very, very widespread. And it wasn't crypto specific, but I think it's important because what the SEC claimed it was doing and why it thought this was important was the materiality analysis was because security was so important to this business that it rose to the level of an actionable misrepresentation. And I think that is true for a lot of crypto-related companies, Web3 companies, where security really is the underpinning of the entire, operation, or the secret sauce, if you will, right? The smart contract has to be extra secure. The chain that it runs on has to be secure. So there is this heightened security aspect to everything we do in the Web3 space, which makes this, I think, sort of a heightened concern for this industry. And the SEC now has added another item to the things that it seems like it's going to scrutinize and potentially bring enforcement actions against. So just something to be mindful of, what can be done if you're operating a company in this space and you have potential cybersecurity concerns. I think you want to make sure that your internal investigations and your outward-facing statements are consistent to the extent they can be. If you identify things, you want to take actions to address those things. You want your disclosures to be accurate if you do have vulnerabilities. A lot of this seems obvious, but it's exactly what got SolarWinds into trouble. So I think that's the reason why we're going to possibly see more action by the SEC in the cybersecurity space.
Justin, just one thing you said struck me there, because I wasn't aware of that case, was that the court said cybersecurity is not accounting, and that may seem really obvious. But I have found so many issues that people run into in this space writ large and investors run into in this space writ large is just a misunderstanding of the basic facts of what's going on. If someone tells me I'm going to invest in crypto, that basically tells me nothing, because crypto could mean all kinds of different things, right? You could be investing in an NFT that is real estate related. And so what are you really doing? You're kind of really investing in real estate, right? You're not really, it has a crypto wrapper on it, but it's, or you can invest in a fungible token, or you can invest in a dollar denominated, token, which is really kind of investing in dollars. So I think it's really important across the disciplines to really understand what the facts are and understand what really at root is the issue.
Yeah, it's interesting, and the SEC has a theory as to why it thinks this fits in their more traditional accounting control rubric, and in fact, they've actually settled with companies under that very theory, so I think we're going to probably see companies not so willing to settle once the case law kind of catches up, with the enforcement actions they're trying to take.
Yeah.
Great, thank you both. And we've mentioned already the two big guys in the US. We've talked about the CFTC, the SEC, and I'd like us to zoom out a little bit now. Let's broaden the lens to the international part. But now on the topic of taxation of staking. So we're back to Sean. We have to go back to the plate of taxes. We are on our legal tapas, legal topics. So
Tapas are
inevitable.
more delicious, though.
You always come back to the olives. You know,
I
you can
mean,
go everywhere, but it's
yeah,
really,
I mean-
yeah, you always come back to the olives.
Exactly. You have like the anchovies, the cheese, whatever, but we still have them. I mean, I love olives, but I know each to their own. So Sean, what are the key challenges or opportunities that you see in the taxation of staking and other crypto activities, not just from the US, but more from the international perspective?
Absolutely. Well, I'll start with the U.S. Unavoidably
Sure, go
so
ahead.
as a U.S. tax attorney. But I think staking illustrates something really important about tax questions in crypto, which is the tax code is developed for a century to deal with all types of transactions. All types of economic activity are covered within this intellectual project of the U.S. tax code and worldwide tax codes trying to map onto this and ultimately tax the underlying activity. Crypto is just another evolution of technology doing this. It's not something so new and so different that requires us to write new rules. So a lot of the times I'll get a call from a client or whatnot, and they'll go, what does the IRS think about this? What does the IRS think about this issue? And that's not really the question. The answer is, what is the tax code's the answer under the existing tax code when applied to this new technology? So staking is an area where I think the answer is very clear about the taxation of staking, that newly created property is not taxable until it's sold. The answer for that doesn't come from some IRS ruling or what some government official says, but from 100 years of case law, the code, and courts having developed it and applying it to the new technology. So I think the opportunity, and you say, what are the opportunities in this? And staking is just but one example. When we see this new technology and how it's being used, the opportunity is really understand the technology and then apply the existing law to that technology and come up with sensible answers that will bring blockchain and crypto into the general mix of other technologies. It should be treated like everything else, and that's really, I think, the opportunity. Globally, I think that the reporting regulations and how those all interplay with all of this is going to be the major issue over the next couple of years. You're going to have a lot of jurisdictional questions about, and ultimately when we get to substance, it will be who has the right to tax that transaction. There's a big principle that there should be no double taxation. No country or whatnot should get two bites at the apple. How that's going to interplay when we have really, really complicated international fact patterns, and as governments wise up to this and taxing agencies wise up to this, that I think is going to be the big issue, but also the big opportunity for thoughtful tax work.
Great, thanks, Sean. And now going back to Olta. So I'd like to know from what you've seen, because also at Owl Explains, we don't just explain. We've explained a lot of different topics, different things that are happening, but also breaking down myths, clearing up misconceptions. So Olta, what's the biggest misconception that companies have about complying with AML and KYC requirements in the DeFi space, particularly when we're dealing with these decentralized protocols?
You asked me one of those questions that I can't stop talking probably for many, many hours. Look, I mean, it's unfortunate that we are dealing with we are grappling, actually not we're dealing, we're grappling with the concept of compliant DeFi. But what is compliant DeFi? But unfortunately, for many DeFi protocols, they're heading toward, I mean, they're forced to abide with AML, KYC, and I think the intersection of privacy and compliance is going to be a big issue, not right now, but for, I mean, many, many years to come. Unfortunately, I don't think we're going to have a clarity, but seems like the regulators are forcing DeFi protocols toward KYC and AML compliance, but I would hope that the government and the industry should come together at least to establish those technical standards in order to identify, I mean, several compliance regarding DeFi protocols, compliance paths, and also to, I think would be helpful to also identify the red flags or to establish that red line on where this DeFi protocol should concentrate in order to mitigate the risks, the compliance risk. I am the general counsel of a crypto exchange. We are a mixed model, a hybrid model, a DEX model, and a SEX model, SEX. I don't like to use, sorry. And I think that it's very confusing, and I have to accept this as a GC. It's very confusing for the users when they onboard and they say, oh, these are a DEX. Why do I have to go through the KYC and AML? But as I said, unfortunately, we try to, my role as a GC is not to eliminate the risk. My role as a GC is to mitigate the risk. And it seems that, for now, we have to deal with this compliance standards that unfortunately were pushed from our regulators. I can talk more and more. We only have 6 minutes, but.
Yeah. Thank you, Olta. Thanks for that. And just my last question is going to be more like a group question, more like a takeaway message. So just a short response from each one of you, because we've seen that we have a diverse set of tapas, of legal topics. And now that I was looking at the title, it should be niche legal tapas, topics, issues, whatever you should care about. I think that rings better with the ear. So if you had to give one piece of advice to a company operating in the digital asset space today, what would it be? Considering everything we've seen, these evolving regulatory issues and the different rulings. So what would your takeaway message be in around a minute and a half for each one of you? So would you like to get started and head down the line?
I'll give a simple one, which is, the firm I work at does a lot of work in tech startups forever. They've done tech startups, they incorporated Apple, they say all of this. And usually when you're doing a tech startup, tax issues are not something you have to be particularly thoughtful of in the early stages. You're getting money from investors, everything's kind of by the books. You get money in from investors, you issue stock, you have to run up losses and all of that, but it's very simple. I would say the opposite is true in the Web3 space. Being thoughtful about tax from an early on perspective. Where are you setting up? What jurisdiction are you operating in? What are going to be the global tax consequences for that? What's your relationship going to be to the United States? How do you want to do that? Doing it earlier on in the process is absolutely crucial to be successful in this, because it's not like in a traditional startup, something you can come in 5 years down the road and then figure out because there's kind of this cookie cutter. It's something that from the beginning, being thoughtful about, caring about, will pay a lot of dividends, quite literally, over the course of the lifetime of a company.
Thanks, Sean. Justin?
I think, a key takeaway is from the company side, unfortunately, the Web3 space has a reputation amongst regulators, and it's a target for regulators in a way that other industries are not. So I think that you just can't be too careful when you're thinking about how to direct your public statements. Going back to the solar wind example, every T has to be crossed, every I has to be dotted, maybe in a way where other companies have to not be as careful. That's on the company side. And then on the individual side, because we were talking a little bit about some tactics in private litigation, there's an opportunity to be a little bit creative and flexible with court. So if you've been wronged and you don't think that your wrong fits in a traditional box, go talk to a lawyer. And there's probably strategies or things that maybe can be done in this environment to either serve the person or find the proper party or trace assets, and it's worth a shot. Obviously the risk reward and the monetary value has to be there to justify a decision, but if it is, it's worth a shot to speak to a lawyer in the space.
Thanks, Olta.
I think for me, having been on both sides of practice, private practice and now in-house, the only advice that I would give to developers, to entrepreneurs, and to founders here is, not because I'm an attorney, but I think you really have to work with an attorney who is not intimidated by crypto. I'm talking here about crypto projects. Usually attorneys are very intimidated by crypto. So you have to find, there is no best or worst attorney, but at least to have those skills to help you navigate those issues. The other thing is, a mentor of mine always asked me the question, do you want to be a risk-adverse attorney or do you want to be a proactive attorney? In crypto, you really have to have the guts to not always say no. I work with developers, with engineers, with amazing founders, and it is my job as an attorney to not say no, but to try to find solutions. Sometimes I am obligated to say no, of course, but it's good to be that attorney to navigate the legal compliance and regulatory issues that we're facing in this industry, of course, in collaboration with the team. So find good attorneys out there, general counsels or outside counsels, but that's my advice.
Thank you, Olta. And David?
Yeah, Sylvia, I really like your tapas analogy, and I'll probably steal that, frankly.
It's because I'm hungry.
Because blockchain has been the most interdisciplinary area of the law that I've ever worked in. every lawyer, if they're going to be a good blockchain lawyer, no matter what their top line specialty might be, has to be sensitive to the array of issues we've been talking about on this panel, because it's such a new area and it's so unformed and it's still evolving. I'd like to analogize working in blockchain to what it must have been like being a securities lawyer in the 1920s, as the law was just in its infancy. And now if you do like some, garden variety traditional finance deal now in the 2020s, 100 years later, you'll get armies of lawyers charging millions of dollars over a paragraph, right? And what the precise wording should be. You can't do that in blockchain. It's just too new, it's too evolving, and there's just so many different things to think about. So my advice would be, think of it like tapas. Think of it as very broad, and you have to cover a lot of waterfront in an area that is admittedly right now evolving and uncertain. And if you like that, it's very, very exciting.
All right, thank you all so much, and thanks for joining us today. I'd like to give a round of applause to our panelists. Thanks for every different issue you brought. And yeah, that concludes our panel. Thanks, everybody. And now it's time for real food. Like, we've already talked about the tapas analogy. Now we're going to have like some actual tapas and steak. So thanks you.
Thank you.
Thank you.